Are you a young adult, a woman, ethnic, cultural, or faith minority? Maybe you've been pregnant or postnatal recently. Well, you might actually be entitled to lower sentencing when it comes to committing crime and possibly, going to trial in the UK court. Although this might actually be changed. So welcome to the Daily Objective. Joining me today is Matthew Humphreys, a solicitor working in criminal defense, to help me understand what this change what this potential change is and how it's going to be changed, and if it wasn't changed, what that would mean for the actual UK courts. So, Matthew, try to first explain basically this new sort of sentencing guidelines came from the Sentencing Council for England and Wales. So can you maybe tell us first what this is, and then we can go into what recently happened.
Sure. So the Sentencing Council, in its current form, has been around since 2010. It's not a new body. In 2010, it took over the functions of, there were two previous bodies which did essentially the same thing between them. But it is essentially a public body which is intended to operate independently of government while ultimately being answerable to Parliament. It consists primarily of a number of members of the judiciary, together with the current director of public prosecutions, the essentially the head of our Crown Prosecution Service, representatives of the probation service, and I believe there's also at least one sort of legal academic member who is part of the council. And their remit or their function is to try to achieve some degree of consistency of approach um, between the obviously the large number of courts across England and Wales, but to achieve some sort of consistency in how they approach sentencing offenders. And part of what they do is to issue guidelines. There are certain overarching guidelines that apply to all offenders who are being sentenced, which we'll come back to in a moment. There are also offence specific guidelines for most of the sort of most common offences, if I can put it in that way, all of which in some way require the courts to take into account the harm which has been caused by the offence, be that financial harm in terms of a theft or fraud offence, or be that physical harm, say from an assault offence. But they also need to consider the mindset of the offender, as in, was this a spur of the moment thing? Was this pre-planned? That kind of thing. And obviously, essentially, something that is, a spur of the moment shoplifting is going to be treated much more leniently than some carefully planned commercial burglary, for reasons which I hope are obvious to people. Um, but coming back to the overarching guidelines, one of those deals with how the court should approach imposing community sentences, prison sentences, and what we call suspended prison sentences, which are sentences of up to 2 years imprisonment. where the court must consider whether to suspend the sentence, which means that the offender would not go to prison unless they commit another offence while they are under the suspended sentence. And for both community sentences and suspended sentences, the court will usually attach a number of requirements which are overseen by the probation service, which can be a mix of things like doing unpaid work in the community, the kind of old-fashioned notion of community service. In appropriate cases, if the defender is a drug addict or an alcohol addict, they can mandate treatment for whatever's going on as part of the sentence. And I think that kind of brings us to what is caused the issue here, which is that this guideline on imposing community orders and suspended sentences has been, well, it's been around for a while. It's not a completely new guideline, but what was going to happen was that the wording of the guideline was going to be amended, was going to be revised. And the issue is that any court who is sentencing an offender, or whatever case, need to ensure that they have all of the relevant information in front of them. And if it is a case which could potentially lead to either a community order or a suspended sentence where there's going to be probation requirements, they need information as to what requirements probation say are suitable or appropriate for this particular offender. And the way that is done is the court will order what we term a pre-sentence report. And before the sentencing hearing, a probation officer then has a meeting with the offender, goes through all of the information they need to get about the offender and about what's going on, what's led to the offending behaviour, and then they draft the pre-sentence report to assist the court. It's common for the court, I will say, to order a pre-sentence report even if it is going to be a custodial sentence. You don't, in that situation, need to know what community requirements are going to be appropriate, because if they're going to go to prison, that doesn't come into it. But it's still common that the court will want a pre-sentence report to make sure they have got all of the relevant information in front of them. And what is slightly different about this revised guideline that was going to be coming in this week, it's now been put on hold for reasons we'll come to in a second. But what was different is that they have the Sentencing Council within the guideline have listed a number of what they are describing as cohorts, which are basically particular demographic groups, I suppose you'd say, within the community, where they suggest that the courts should always be ordering a PSR before proceeding to sentence. There's been some media coverage and subsequently some comments from certain politicians suggesting that the effect of this would be that the groups identified in those cohorts would be less likely to receive prison sentences than people who are not part of those cohorts. Um, so we've then had, in the last couple of weeks, a very big argument between our Justice Minister, Miss Mahmood, and Sir William Davis, the chair of the Sentencing Council, who is one of the senior judges in the Criminal Court of Appeal here, with the Justice Secretary wanting this particular wording about the cohorts taken out. And I think about a week later, that was on 19th of March, I think she wrote to Sir William Davis saying that she objects to it and she wants it taken out. And then a week later, Sir William Davis wrote back to her saying that they've had basically an emergency meeting of the council to discuss what's been said in her letter. They, at that point, were saying they don't think it is necessary to remove the wording, that the criticism, in their view, is based on a misunderstanding, and that this isn't intended to or going to have the result that the cohorts are less likely to receive custodial sentences. And the point, which I think is a fair one, which has been missing from a lot of the media comment I've seen, is that simply ordering a pre-sentence report for a particular defendant doesn't by itself mean that they're not going to get a custodial sentence. Whether they are going to get a custodial sentence depends on the sentencing guidelines for the particular offence that they're being sentenced for, or in the case of the most sort of serious offences, stuff like murder, etc., well, it's bound to be custody anyway, irrespective of whether there's a report. Although, as I said earlier, in many of those cases, the judge still will want a pre-sentence report to make sure that they have got all of the necessary information about the individual they're sentencing. So what happened afterwards was that the Justice Minister essentially emergency drafted some proposed new legislation, which would have essentially overridden the Sentencing Council guideline, and stated that courts should ignore that particular section about the cohorts. It has now been recognised, the latest sort of update from yesterday, it's now been recognised that the government would not be able to get that legislation into law until at least May, by which time this new guideline would have been in force for about a month already, because it was due to come into force this week. So at the same time as the Justice Minister recognising that, the Sentencing Council have now said they are going to pause the new guidance, and I suspect there will be some discussion about how to perhaps clarify the wording to sort of avoid this misunderstanding that seems to have happened in a number of quarters about what they're actually saying.
So to basically wrap up, starting with the sentencing council, I think the existence of it seems to make sense. Basically, you wouldn't want, uh, especially when you have so many courts, you wouldn't want to your sort of luck when you go to a trial. You wouldn't want it to be, I'm getting this judge, so yeah, I'm getting life for stealing an apple. Well,
Exactly.
it's probably not as drastic as that, but basically having some sort of certainty or some sort of uh, basically basic sort of understanding of what the sentence for what kind of crime is I think a good thing. Now, uh, the idea of that specific sentencing council being independent, I think also makes sense. You do want an independent judiciary, although technically this is not sort of what normally we think of as judiciary. It's more of a sort of like standardizing council. But now, with the idea that the parliament would come in with a new law to basically tell this independent council to basically no, you have to change it.
Hmm.
That sort of well, you did mention that it is ultimately answerable to parliament, as usually all power is. So in what way is it answerable, especially when it comes to, they put out the guideline and the parliament comes in, no, you cannot do that.
Well, they are accountable to Parliament, and this is the bizarre thing: is that the consultation on changing this guideline has actually been going on for a number of months. In fact, I think I'm right in saying since before the general election last year. So, one thing that is really baffling me is why no one has raised an objection up until we have the proposed wording coming out last week or 2 weeks ago, when it should have been pretty clear, certainly at the Ministry of Justice, for a number of months. Even if they didn't know the exact wording, it should have been pretty clear what the upshot of the redrafted guideline was going to be. So that I think needs explaining. But as I say, they are by law meant to be independent, although ultimately accountable to Parliament. And it just seems to make a complete nonsense of that for the Minister of Justice to then turn around and say, well, we don't like what the council's actually done here. We're going to pass legislation and overrule them. It just makes a nonsense of the whole idea that they're an independent body in the first place.
Now, we're gonna go. I want to go a bit further into sort of the motivation I think that was behind this sort of new guidelines. But first, we have a super chat from Apollo Zeus. Thank you so much. Super chat from Bonnie. Thank you so much. Also a comment from Bonnie that I want to read out. It sounds like they are taking some discretion away from the judges, or maybe I'm mistaken. I'll go to you, Matthew. But my understanding is for the most part, it's basically something this like pre-trial or pre-sentencing sort of report is just something sort of on top, but uniquely or sort of at the end of the day, the full discretion is still within the judges.
Well, yeah, I mean, guidelines are guidelines. The it's as long as we've had sentencing guidelines, it's always been the case that the judge has the discretion to essentially set them aside if they believe it's in the interests of justice to do so. They can go outside of the guidelines. This particular proposed guideline makes clear that it is up to the judge ultimately whether to order a pre-sentence report. There are circumstances where particularly if it's inevitably a prison sentence and they don't need probation's view on appropriate community orders and so forth. It's perfectly open to a judge to take the view that they have all of the information that they need without getting probation involved. Though, as I say, the judges often will still want a pre-sentence report.
We also have a super chat from Apollo Zeus. Thank you so much. He's asking, is it true or a myth that women get less harsh sentences than men historically for the same offense? Anyway, I mean, that is something I've heard before. I don't know how true that is. Matthew, maybe someone who works in that field, you know, a little better.
Um, I think there are particular circumstances where that can be true. I don't know if that's true across the board, but say you have an offender who is pregnant or who has recently given birth, unless it is a very, very serious offence, um, that is, something which might sway the judge from imposing immediate imprisonment to imposing some sort of community order or a suspended sentence, because they have to take into account who's going to care for the baby if the mother is put into prison. And I appreciate that may seem like a slightly cynical situation, but the reality is that you do have to consider, if they have caring responsibilities, what's going to happen to the child that they're caring for.
Now, as uh, as you mentioned earlier, the Lord Justice Davis has at some point replied to the Justice Minister, and I think it's really interesting to read through that. So he sent a letter basically saying, "The rule of law requires that all offenders are treated equally and justly by judges and magistrates who are fully informed about the offenses, the effect on the victims, and the offenders. The section of the guideline relating to pre-sentence reports is directed to the issue of information about the offenders, no more and no less." And when you read through it, it's yeah, a just sentence. A judge needs to know. But when it comes to what specifically we are talking about here, it's, as we said, their cultural background or their ethnical background, their religious background, the fact that they are a woman or they are a young adult. And that really seems to, at least me, sort of going back to philosophy, it really does seem to have its roots in this sort of basically rejection of free will, and this idea that you are merely sort of the result of the actions acted upon them. So if grew up in a certain, if you have a certain ethnical background, then you are on a different, you were offered sort of a different kind of a world that compared to a white straight whatever old guy, and therefore we need to make the world more equitable. We need to basically correct for those differences. Matthew, do you think that is sort of at the root of it, or what is the root of basically this change?
I have to say, quite honestly, I don't think that's the root of it. I think Sir Brian is being absolutely upfront and honest in the letter that he's written, that it's simply about ensuring that the court has all of the information that they would require about the defendants.
Well, okay then. Well, I guess
Well,
we'll see. Yeah,
I mean, I have just to
yeah.
perhaps put a bit of context in. Historically, before we had the sentencing council, and this is going back a few years, obviously, there was some statistical evidence to suggest that sort of ethnic minorities were more likely to receive custodial sentences than white people for the same offence, and sort of all other things broadly being equal. So, in terms of achieving consistent sentences, certainly originally part of the function of the sentencing council was to try to address that issue and make sure that particular factors weren't being missed because defendants were from minority groups. But I don't think any of it comes from a denial of free will necessarily. I think it is about trying to make sure that they have all of the information so that people can, as far as possible, be treated equally.
Well, I guess we will not see what the result of this would be, since it has been sort of paused by the sentencing council and will most likely be changed by the parliament, who, as I said, as you mentioned earlier, sort of use the arguments that basically it.
I suspect actually we may end up with the sentencing council sort of clarifying the wording in some way in order to address the concern rather than. I mean, I have to say it would be completely unprecedented for Parliament to actually, pass this legislation and legally overrule them. So I think it's more likely we will see a further revision of the wording, I have to say.
So yeah, we'll definitely follow that and see where that will take us. Again, something. We have a super chat from Paul Zeus. Thank you so much. He says, "Your opinions on, in quotes, ignorance of the law as no defense in relation to cultural differences."
Can you tell me the question again, sorry?
I think that the way, so just to say it again, your opinion on, in quotes, ignorance of the law as no defense in relation to cultural differences. I think the idea is that people from minority groups do not know what the law is, and basically that being used as a defense for maybe lighter sentence or anything along those lines.
Well, it's not a defence, is the short answer to that.
Yeah, and again, if law is indeed in such a case where it is not, a common person is not able to understand it, that's not a good law. That needs to be changed. A law should be objective, as we say, especially in America. I don't know if in the UK you do the jury system, but basically the purpose of a jury is also that if law is so complicated that you cannot explain it to 12 common people jurors, then you might have a problem with
There
that
is an
kind of a law.
issue over whether, yeah, exactly.
Well, anything you'd like to add, Matthew?
Um, no, I don't think so.
With that, we'll continue today on the reality show. Well, we'll discuss Trump's tariffs. So make sure to join us on that. Link to that is in the chat. Thank you, Matthew, for joining me today. Thank you, everybody, for watching, and bye bye.
Thank you.